today's working session, alternate dispute resolution mechanisms, how far successful. Let me begin this by just giving an introduction. What are ADRs? Anything alternate to litigation? Well, the dynamics involved in these processes determine whether a process is actually an alternative to litigation as a mode of dispute resolution. Before we begin with that, let's take an example of Orange story, which was introduced to me when I was introduced to these processes in a very different way at Harvard. They said that there's an orange between two sisters, they are fighting over the orange, and who will have the orange? What will happen in litigation, in court? How will they determine this question? Is they will say, okay, divide the orange, or who bought the orange first, or who should get the orange? Well, in mediation, what happens? For example, the mother actually adopted this approach and said, well, asked one daughter that, why do you need this orange? They said, I need the fruit. The other daughter said, I need the pulp, the peel of the orange to use in the cake. Well, mediation has the dynamics. The dynamics, for instance, in litigation, the participants, for instance, are the plaintiff, the defendant, the judge, the plaintiff's lawyer, and the defendant's lawyer. There is strong communication between plaintiff's lawyer and the judge, and between defendant's lawyer and the judge. But there is weak, estranged communication between plaintiff and defendant. Perhaps there is no communication between plaintiff's lawyer and defendant's lawyer, and no communication between judge and plaintiff and the judge and the defendant. The dynamics in arbitration is also similar. But due to other reasons, such as expert determination and party-chosen judge, has merits as a dispute resolution process. Arbitration, as compared with other processes of dispute resolution like mediation and conciliation, is a formal way of resolving disputes. The same dynamics, because it's represented by the lawyers, and they cannot be clubbed with them under the same genre of ADR mechanisms. In mediation, there is strong communication links between plaintiff and the mediator, and defendant and the mediator, even though they can be represented by a lawyer, but the communication link is never weakened. Mediator facilitates the dispute resolution process through effective communication, and hence has a great chance of developing a strong communication link between the plaintiff and the defendant. In negotiation, even though parties can be represented by their lawyers, there is a chance of facilitative communication link between plaintiff and the defendant, as the aim of this process is to look at the interests rather than positions. While dealing with dispute resolution, what we generally do is we think, okay, litigation is one aspect and ADRs are the other aspect, and we club arbitration, mediation, and negotiation in one group. Whereas arbitration is a separate proceeding altogether, mediation is a separate proceeding, negotiation is a separate way of resolving disputes. Well, in US, they have already done that, and they have adopted multi-door courthouse approach. There's a program in Harvard which is dedicated to a multi-door courthouse in which the dispute resolution is actually taken into stages. First, they try by negotiation, then they try the same dispute by mediation. If required, they go for arbitration, and some disputes are resolved through litigation. After the procedural, arbitration cannot be considered to be an ADR mechanism if we club it with mediation conciliation. Now, ADRs in India have the judicial support. The Honorable Supreme Court of India has passed many judgments stating the importance of ADRs and constructing a roadmap for its successful adoption. The Salim Bar Association case. The empanelment of lawyers has been done to carry out mediation and conciliation. This court-ordered mediations has failed considerably. The participants look at this process as a waste of time, and generally nothing comes out of this exercise. The primary reason for such failure is the lack of knowledge of the dynamics involved in the process. The process is not clear. We say, okay, not litigation, then either ADRs. Now, what are ADRs? Well, as Mr. Basine has rightly pointed out, the lack of training is there. We have the legislative support. The Arbitration Conciliation Act is there. Section 89 of the Civil Procedure Code has been amended and introduced 4 processes as a mode of settlement of disputes outside the court: arbitration, conciliation, lok adalat, and mediation. The law curriculum is there. The law students are trained by a course named as Arbitration and ADRs. It's a semester-long course. The seminars and conferences are there. There are ADR institutions, but not as good as rightly pointed out by Mr. Basine. Well, talking about success of arbitration or success of ADRs in India, we need to adopt them first and then talk about the success. So I would like this working session to more emphasize upon successful adoption. We pay a lip service by adding ADR in the curriculum. ADR should be a full course spreading over a semester. ADR should be emphasized while teaching the Civil Procedure Code. Lawyers trained in few days may not be able mediators or negotiators. There has to be continuous training and retraining programs Now, the future plan for successful adoption can be, we need to adopt a full training course in law schools for the law students. At present, ADR course is clubbed with arbitration, and it is taught as arbitration and ADR as one subject in one semester. The emphasis in the law schools and other organizations dealing with lawyer training is only on moot courts, where the students or the participants are divided into two groups, either plaintiff or defendant. You're speaking for one party, or you're defending the other party, thereby emphasizing the importance of litigation as the mode of dispute resolution. Students know ADR is something relating to mediation and negotiation, but lack completely the knowledge of the processes. Similar is the experience with the lawyers, the lack of basic understanding of the dynamics of this process. We look at positions and not interests. For example, in the orange story, we just looked at the position. Do you want the orange, or do you want half of it? In case of litigation, the end result would have been divide the orange between the two parties. Whereas, had it been a mediation, they would have got to know the interests of the parties. We decide the disputes but do not resolve them. Only ADR mechanisms are equipped to deal with dispute resolution, not dispute decisions. Litigation is promoted by all the players in the dispute resolution. Legislation promotes it, society does, and lawyers promote litigation, and even the judiciary. ADRs are not there even if they are there. To promote something, it has to be in a special way. Few clarifications while dealing with ADR adoption or success. We need to keep in mind that not all disputes are capable of resolution through ADRs. By adopting ADRs, I do not mean to say that litigation should not be resorted to. Some disputes are best resolved through litigation. Lawyer training should not be only ADR or only mooting. It should be a combination of both, with specialization chosen by the student as he/she progresses in the legal education. We need to take into account the training of all the players. People who will train these the lawyers or the students should be trained first. Starting from the training of the trainers, legal education reform, we should target the law students who are next generation lawyers, and they should receive quality education in ADRs so that they would be able to adopt in their practice. Lawyer training programs, continuous professional development programs, mandatory programs, existing lawyers should be trained in these processes extensively so that they completely understand the dynamics of this process. Incorrect knowledge of the processes can be harmful for the future development of these processes. What we think of mediation or negotiation may not be correct, and this incorrect knowledge can be harmful for the future development of these processes. Lawyers need to be educated that these processes will not reduce their work, but will have more people coming to them to resolve their disputes, which otherwise are not pursued because of lengthy litigation process. Judges need to be trained, promoting research in ADRs, training of society through media to make them aware of these processes. Whenever in my personal practice I talk to a lawyer or talk to another person, let's mediate the claim, he says, what are you talking? I mean, the other lawyer does not know how to negotiate. If I come and say, let's negotiate over this claim, over this dispute, they will like, well, let's see you in the court, take it or leave it. The lawyer fee schedule should be prescribed for acting as mediators and negotiators, thereby educating the society as well as the dispute resolution should be preferred, and lawyers adopting that in their practice need to be paid for that. By having more of such conferences dedicated to ADR adoption, which can develop these processes further. Circumstances in India require Indian way of adopting ADR mechanisms. What we do in India is we look at the Western society of the developed countries and the present state of ADRs there and try to incorporate the same here by implantation. What we forget is the differences in the stages of development. Mindset of judiciary, society, lawyers, organizations. They have come to this stage of ADRs after going through a history of development. Though we do talk about the historical presence of them, but formal introduction of ADRs in India in the legal system is recent. Hence, the development curve of ADRs in India will take its own time, and we need to continuously work towards its adoption and improvement according to the change that the society will undergo in the future. These are dynamic processes, and the outlook of society has to be changed for its success. We impose laws on the people, and they will lack of acceptance. We use sanction as a mode of obedience. For example, seat belt laws. What we have, we impose seat belt laws, and we say that you wear the seat belts. But I've seen most of the people not obeying that law because they think that it has been imposed on them. Even in the US, I've seen people not wearing seat belts because they think that it is imposed on them. Now, when we need to adopt law, people need to know that it is for their benefit. Before introducing the law, there should be an education of the people about the new concept and let the people gradually adopt it as a way of life. Now, for example, people brush their teeth not because there is a law. They do it for themselves. People need to adopt these mechanisms not because it's for lawyers, it's for judges. It's for them. It's for their benefit that the mediation and negotiation and conciliation is for their benefit. The social cultural differences require that a special way of introduction by which the society adopts it, like a trend, like a brand of dispute resolution. By this, ADR mechanisms perhaps may be successful. Thank you.
Thank you, Mr. Jain. Now I'll request Justice R.S. Rathore to kindly place his paper.
My Lord Justice Sadasivan, Judge Supreme Court of India, Mr. Lalit Basit, Mr. Deepak Jain, Mr. Kaushik, the distinguished guests in this august house, including members of the bench, members of the bar, and students, and ladies and gentlemen. You just heard a member of the bar on the topic, an expert on the topic from Harvard, and now it is a turn of member of the bench. And for that, I would earnestly request that it would be better if you have the elder brother on the topic and listen to his enlightened speech which he would be giving, my Lord Justice Sadasivan Sahab. However, because I have been directed to say a few words, as a law-abiding citizen, I propose to say a few words, and without taking much of your time, because we all wait for the speech of my Lord Justice Sadasivan Sahab. For a common man in India, there are broadly two hurdles to secure justice, namely heavy expenses and delay. Sometimes these hurdles are so grave that poor and downtrodden prefer to suffer injustice rather than to enter into a course of litigation, highly expensive and indefinite, which is sure to ruin him. It is to overcome the time-consuming process, enormous expenditure, legal complexities, and cumbersome legal system, and also as a device for relieving the courts of heavy load of cases, it is required that alternative dispute resolution system should be adopted. This system of alternative dispute resolution is not foreign to us and to our society. The ancient Indian history bears the testimony that village disputes were settled by village elders or mukhias or patels, and this decision was known as Panch Faisla, which was accepted by the parties. The role of the mukhia was that as a decision was that of a decision maker, a mediator, a facilitator for resolving the dispute at the grassroots level. Similar was the system of Nyaya Panchayat in the village, which was mainly based on conciliation and compromise. Subsequently, the colonial system, legal system came to be adopted in our country, which with the advent of British rule. The said system had many merits, but it was not fully suitable to our society, the financial conditions, and the local environment. Later on, after having attained independence, our legal system gradually modified and even enactments were passed which were based on the principle of ADR, as for instance, statute dealing with the industrial and matrimonial disputes wherein the settlement of dispute was by way of conciliation was one of the modes. There is a self-contained provision under section 23 of the Hindu Marriage Act, according to which you all know, before proceeding to grant any relief,